Hello and welcome. Thank you for staying with us on your Sunday evening while you get ready for the work week ahead, or maybe squeeze in that final bit of Sunday relaxation. I'm Jabari Fraser. This is A Current Affair. Remember, you can send us your comments and suggestions on Twitter at TV6TNT or at Jabari Fraser. Don't forget to use the hashtag A Current Affair. Give us some feedback on Facebook too. CCN TV News is the name of our page. There isn't much that we can discuss about Austin Jack Warner, the politician. That hasn't been said as yet, but one area that hasn't really been looked at with great detail is his possible extradition and all of the legal ramifications. In 1996, Trinidad and Tobago entered into the Mutual Assistance in Criminal Matters Treaty. At the time, Ramesh Maharaj was the Attorney General. Since then, there has been significant collaboration between Trinidad and Tobago and the United States. Here on set with me this evening is David West, who is the former head of the Central Authority.
Good evening.
Hi, Mr. West. Also on Skype, I have Roger Archibald, who is a Jamaican-American attorney. He's practicing in Brooklyn. And on the phone is Ramesh Maharaj, former Attorney General of Trinidad and Tobago. Good evening, all.
Good evening.
Good evening. Good evening to you. Good evening to all of the
Just making sure everyone is hearing me. All right, so I want to start with Mr. West. What is the procedure when when there's an indictment from the U.S. or from any other country, and then there is an extradition request in Trinidad and Tobago?
Okay, what would have happened was the grand jury in America would have handed down an indictment based on certain charges in the United States of America. That indictment would then be sent over to the Department of Justice in Washington to be sent to Trinidad Central Authority for a request for extradition. Now, the request can either be a provisional request or what we say a full request with all the evidence accompanying the documents. Now, in this matter with regard to Mr. Warner, it was a provisional arrest. So the Central Authority would have received the documents. That would be the indictment, the grand jury indictment, the arrest warrant, and a brief information on what the charges are. And then with that would be faxed down to Trinidad, and the Central Authority would then contact our local Interpol bureau, and they would then go across to the magistrate's court, let the magistrate sign the warrant of arrest, the local charges, and then the Interpol will collect the warrant, and then they would go and arrest the person. Now, at that point in time, the Attorney General does not have anything to do with the procedures because it's a provisional arrest warrant. It's not a full arrest warrant. It's only when the authority to proceed is signed by the Attorney General, then it becomes extradition proceedings. Okay? So once the person is brought before the court, he can apply for bail. Once bail is granted, the matter is adjourned until the evidence comes from the requesting state, which is the United States of America in this instance. Okay? Once the evidence comes to the magistrate's court, once the evidence comes before the Central Authority, it is then disclosed to the defense side, and an agreed date for an adjournment, an agreed date for trial is agreed to.
Right.
Once that date is agreed to, then we have two witnesses coming from the requesting state. That's the permanent secretary, who received the evidence, and also she would also tend into evidence a certificate of speciality, and also to the arresting officer to say, yes, I arrested the person named in the warrant.
Right. What if the person wasn't technically arrested, as what happened with Mr. Warner? Or does it matter if you surrender or if the police come for you?
Well, he would be arrested. Okay. So he has to be arrested to be brought before the court. He cannot just voluntarily go before the court. There must be an arrest warrant.
Okay.
Okay? So once that is done, then the defense can then make a submission of no case to answer based on whatever defects they see in the extradition proceedings.
Okay, I want to bring Mr. Maharaj into the conversation now. Mr. Maharaj, once you're still hearing us, how long does that process, once the person has been arrested, typically take until extradition?
Well, it can take a short time, it can take a long time, depending upon the evidence which has been put forward and depending upon the extent of cross-examination. That is all part of the due process of law. And it depends upon the court, it depends upon, how long the court sits on a particular day. And it depends upon whether the persons are represented and whether the persons are going to have an all-out fight locally. But I think that there can be cooperation to try and expedite the process.
And Mr. Archibald, once you're still hearing us, what I'm putting to you now is how much challenge can there be from the person who is being arrested or has been arrested? How much can he challenge the system and prolong his extradition, possibly?
Well, the extradition treaty basically sets forth the areas of challenges, and those challenges are separated between merely technical challenges, like, for example, if the warrant was defective in some way, didn't contain authentication from a magistrate here in the States, or possibly some of the documents weren't properly notarized. Those are purely technical challenges, and they could end up getting the extradition process slowed down or have to be started all over again because of some imperfection. You could also challenge them based on certain legalities, like constitutional provisions. He could challenge based on due process by saying that his rights were in some way abrogated by the entire process. But there seems to be a particular area that a lot of defendants use, and that is that it would be oppressive, it would be unjust, it would be inappropriate for them to be extradited to the States because the venue is inappropriate. Maybe the penalty here may be more severe than the penalty in Trinidad, but the same types of crimes. And those arguments are very ripe for exploration between the courts. And as a matter of fact, we've had several cases in your jurisdiction where those challenges were made, and in some instances they were successful. For example, in the noted case from 2011, the Ferguson case, where they successfully challenged, they were able to defeat the extradition and had their case tried before a Trinidadian jury, which in my view would be much more favorable and lenient as opposed to an American jury. I think Mr. West was in some way associated with that case back then, and he may have some additional insights he'd like to share with us.
Gentlemen, before we move any further, I just want to play a little bit of a soundbite, because this is something that Jack Warner has been saying for the last week and a half or so, and maybe you could each chip in on the possible effects of what he has been saying. And don't forget, you can always interact whenever you want if you hear something that you want to contribute to. Jack Warner has been painting his own picture of what he believes could be behind the charges and indictment. He believes that there are socio-historical and even political factors that play in what's going on now. Let's listen to what he had to say.
Why is it, of course, only third world countries are charged? I ask myself, why is it only third world countries? And I'm telling you guys, this is much bigger than I think. As he asked me a question, I mean, Gavin, Nicholas, I would like to say us, like not once, you will sign, I think in 15 minutes, not once you asked me a question. You have a team assembled for the court, and by chance we heard it to rush with our lawyers to the court. Guys, that can't be right. And I'm saying, but there's a whole program of the government to win an election. It just can't make sense, right? And on top of that, you sign my thing in 15 minutes, but Ish and Steve in 3 months.
Mr. West, is there any comparison between the Ish Galbarancing and Steve Ferguson situation and Mr. Warner's situation?
The only comparison so far is the charges on money laundering, racketeering, mainly is a breach of the United States RICO statutes, okay? The Ferguson and Galbarancing case was different in this matter because there was a subsisting local charge based on the same facts as the extradition matter. So therefore, that is why the Ferguson and Galbarancing matter was not successful, because the judge ruled that the correct forum would be Trinidad and Tobago. Now, Mr. Warner mentioned that Mr. Nicholas signed the document in 15 minutes. Now, Mr. Nicholas, up to now, has not signed any document. It would have been the magistrate who would have signed the arrest warrant, not Mr. Nicholas. Okay?
So what he's saying is factually incorrect?
It's factually incorrect.
Okay.
Only when I said the authority to proceed is brought before the Attorney General to sign, when all the evidence has come down, and then Mr. Nicholas be called upon to sign the authority to proceed, which is actually the start of the extradition proceedings. Right now, it's only provisional. A formal request has not been made for his extradition until the evidence comes down and the authority to proceed is signed. So that is the fundamental difference so far. Now, of course...
Gentlemen, if I may interject. What I think Mr. Warner is also intimating here is that he believes that this prosecution is politically motivated. And I believe he's trying to lay the foundation to successfully defend this extradition in that, you know, in particular, Section 4 of the extradition treaty sets forth certain prohibitions to extradition. And one of them is politically motivated types of charges. And I believe, if you read between the lines, what's being said here is that because he is claiming he has certain evidence on certain political figures within the Trinidadian government, that they somehow may have contributed to his indictment in the United States. Now, I'm in no position to comment on the validity of any of those statements, but in a bare-bones skeleton way, I believe he's trying to make out a colorable claim for political prosecution.
That's a very interesting point you're raising there, Mr. Archibald. I want to fully explore it when we come back. We have to take a quick break. I hope Mr. Maharaj is still on the line. This is the current affair.
I'm sure.
Very well. Welcome back. Just before we went to the break, Mr. Archibald, who's on Skype from New York, an attorney, said and was raising the point that if possible, what Mr. Warner could be trying to do is trying to raise an issue of political interference in the process some way, and that could possibly influence the outcome of the extradition. Mr. Maharaj, how is that possible, if it is possible at all?
Well, in the extradition law, if there's a request for extradition, the person can say that the request, he can allege as a possible reason for the court to investigate it, whether the whole request is based on political motives, and as to whether he will be able to get a fair trial. One has to understand that the mere fact that there's a request for extradition, and this was one of the matters we discussed with the Americans and with the Canadians and the British when we were negotiating the treaty, is that there is full due process of law of a person against whom that request is made. And therefore there is the presumption of innocence, and that there is evidence which has to be led, and there be all the possible defenses available to the person against whom that request is made. So what Mr. Archibald said, that and there can be many other issues raised, and you have to remember that in Trinidad and Tobago, as in many of the countries of the Commonwealth, you have a situation where at the magistrate's court, for example, a person can even judicially review a decision of the magistrate. So this process can take very quickly, and it can also take a very long time.
Okay, this is a very technical legal discussion. Mr. West, do you think that that could possibly influence the outcome of the extradition request?
Well, to raise the defense of political motivation could only be raised in the High Court. It cannot be raised before the magistrate, because the magistrate, under our statute, is only concerned with whether the offences are an extraditable offence, whether or not there's sufficient evidence to prove the alleged charges, and whether the person before the court is a person wanted in the United States of America.
So that could, in other words, could take a very long time to reach that point?
Yes. Now, once the person is committed for extradition, then under Section 13 of our Act, they have 15 days within which to raise habeas corpus application, to make an habeas corpus application. Within that,
which for the common man means?
Means to get the body out. I should be free. Now, there are only certain matters that comes under Section 13, which is like, for example, delay, unjust and oppressive to extradite me, okay? Now, the political matter, it will be for Mr. Warner to prove on a balance of probabilities that the U.S. request is based on political motive. And then he would have to bring evidence before the court in the forms of affidavits, okay, to show that there's a political motive for him to go to the United States of America. Now, when it comes down to unjust and oppressive, we have to, as Mr. Maharaj says, we signed a treaty with the U.S., so we have to believe in their court system. And therefore, we have to believe that the request is made on bona fide.
And that is not unjust and not oppressive.
Exactly. So therefore, Mr. Warner has a huge hurdle to climb to prove that.
Maybe Mr. Archibald could come in there and say, well, I can ask you, Mr. Archibald, how difficult is it to prove in Jack Warner's case, especially since he was saying that this is not something that has been affecting people from the first world, for example, Sepp Blatter and so on. It's only people like Jack Warner and other people from the Americas and so on. Is it difficult for him to prove that the request is unjust and oppressive when it reaches to the High Court, if it does?
I would think he has a very high hurdle to overcome. However, you need to also realize that although 14 individuals were indicted, there are another 25 unindicted or unnamed co-conspirators, a lot of whom are from the first world. So that argument may not, carry a lot of weight when all is said and done. Now, in a lot of these federal types of cases, the government builds their case based upon information they gather from co-conspirators that make deals with the government and enter into cooperating agreements. For example, just 2 days ago, we were given an opportunity to see the transcript of a co-conspirator, Mr. Chuck Blazer, that pled guilty in 2013. And we're only now in 2015 seeing what he said. And he went around wearing wires and taped conversations with many of the other co-conspirators who have yet to be named. So I think Mr. Warner would have a very difficult road ahead of him to prove his case, but that doesn't mean that he can't. He certainly could prove his case if he comes forth with the affidavits and other types of admissible evidence to prove what he's saying.
Mm-hmm. Can I just jump in there?
Sure.
I'm sorry, if I may intervene, can I?
Yes, Mr. Maharaj, go ahead.
Yes, but just to also remember that in Trinidad and Tobago, there's a special provision under Section 14 of the Constitution. And under Section 14 of the Constitution, in any matter in the magistrate's court, a person can ask for that matter to be referred to the High Court on the basis that it involves a question of the breach of his fundamental rights or possible breach. And therefore, it depends upon what Mr. Warner is going to allege. If it falls within that category, it could mean that the extradition proceedings can be stayed before the High Court determines the matter. So there are all kinds of possibilities in this matter, and therefore it can take a very short space of time in order for it to be determined, or it can take a very long period of time.
Mr. West, you wanted to say something?
Yeah, just regarding the evidence admissible in Trinidad, our Extradition Act allows for hearsay evidence to come in to be admissible. So therefore, the use of wires and all that, although it would not be admissible normally in our courts in Trinidad, it will be admissible in the extradition proceedings.
Right, because it's under U.S. law there, or exactly why?
No, because it's hearsay and it's allowed to be admissible. Once the evidence is properly certified in the United States by a judicial officer or prosecuting officer, it is admissible in evidence.
Mr. Archibald said something there about a human rights issue being raised. Is it possible for the Inter-American Commission on Human Rights or some superior international law to eventually come into this?
Well, yes, Mr. Warner could appeal to that body, or he could, but as Mr. Maharaj says, it can take a short time or it can take a long time. He can appeal all sorts of issues if his counsel determines that as a good defense. Okay, but what I'm dealing with is the evidence is very broad, and once it's admissible in our courts, it is allowed into evidence. So therefore, whether or not he has a prima facie case to answer to will be it's very easy to cross that hurdle under our law as it stands.
Okay, I'm going to take a quick break right now. When we come back, we have a few more sound bites to play, and we'll continue the discussion. A Current Affair. Welcome back, A Current Affair. His second-in-command, Jack Warner's second-in-command, attorney Rika Ramjet, has also expressed the view that due process may not necessarily have been followed up to now.
Matter of fact, when Mr. Nicholas signed off, he himself admitted that all he had before him was the charges itself. He had not seen anything, nor had he asked any questions, nor was any question posed to Mr. Warner. So I don't know how you conclude that you want a provisional warrant based on no questions whatsoever to the person to whom you are going to indict.
That was Rika Ramjet, chair of the ILP. She's saying that no questions were asked of Mr. Warner. Did the Attorney General or the Central Authority have any duty to ask him any questions?
There's no duty whatsoever to ask Mr. Warner any questions. As I said before, it's a provisional warrant. There's very little evidence you need to get a provisional warrant from the magistrate, because its nature is an urgent warrant, an urgent application. It's when he gets the full documents, he will see all the evidence against him. Okay?
And Mr. Maharaj, does that reflect any sort of deficiency in the law, maybe, since the provisional warrant doesn't require much evidence per se?
I don't think so, because when we drafted the treaty, it was based on what was internationally accepted at the time.
And has that changed since?
And I don't think that was a requirement in any of the other countries that we looked at.
And has that changed since then, since it was first, the legislation was first passed?
Well, I don't think so. I think that has remained, it has remained the norm. But you remember, law is a developing thing, and persons can allege, and the courts will have to determine whether that is necessary. Because even if something is not mentioned in relation to the exercise of public power, the courts have held that it has to be exercised fairly, and in some cases the courts have held that fairness demanded for a person to be heard. So it's a matter of how the court will interpret these instruments.
Mr. Maharaj, if you recall, the Act is very specific, and the magistrate on the adjournment must tell the fugitive or the person wanted that they have 60 days within which to produce the authority to proceed. So you're not held in extradition limbo. You know on July 30th you will get the authority to proceed. And also too, the magistrate, once this section is completed, this part, must then write to the Attorney General and inform him that she has signed off on a provisional arrest warrant, and this is the evidence she has used, and therefore she awaits his authority to proceed. So there are safeguards built into the Act, which Justice Corcoran found the Act to be constitutional when Mr. Ferguson and Galbraith challenged the constitutionality of the Act.
I want to ask Mr. Archibald now, since Interpol has become involved in this, and he has been highlighted in red as one of the people who is very important in international matters in general, does that change or make more urgent the extradition at all?
Well, the extradition process is just that. It's a process, and Mr. Warner would have all of his remedies and all of his challenges in place that he would make at the different stages of this. So America, unfortunately, is somewhat in the back seat. They have to sit and wait for the local process to be had before they can do anything. And unfortunately, this process could go all the way up to the Privy Council, if necessary, before the ultimate decision to extradite is made.
It can go to the Privy Council several times. And,
right.
and another layer would be, when it comes to the Attorney General writing his signing off on the warrant of surrender, if and when we get there, the defense team can then challenge that in the courts again.
How likely is it, or typically how successful are defense teams in challenging issues such as that?
Well, they were successful in the Ferguson and Galbraith matter, I did a matter where I challenged the Attorney General's decision to surrender, and I did not succeed. But it can happen, and therefore you can go back to the High Court, Court of Appeal, and Privy Council again for that. So it could be quite a while before Mr. Warner does leave these shores.
Mr. Maharaj, how long could this possibly take? Is there any outer limit that could be set on this matter?
Well, I have regard to the avenues available for challenge. It depends a lot on what are the facts that Mr. Warner can allege and what are the legal points which can be raised. But I can see that a matter like this, and having regard to the court system, can take 3 years and can take even a little more, and it can even take less. Remember that in Trinidad and Tobago, in judicial review, there's a right of appeal right up to the Privy Council. And you can have several challenges to several actions in the process. But it all depends upon whether there would be facts or evidence to support matters and the kind of legal points which are being taken, and if the points have merit. Because then you'll have the courts having to listen to the arguments on both sides and then make a decision.
Okay, thank you very much for that. Now, before we take another quick break, we're going to have our weekly parliamentary I segment, which is called Where MP. And for this week, who else but Austin Jack Warner? These figures are for his representation under the UNC symbol and under the ILP's oil rig and Keystoke. Take a look.
Look your MP, but where? Look your MP, where? Look your MP, look him there, looky there, don't let him get away. Look your MP, but where? Look your MP, but where? Look your MP, look him there, looky there, don't let him get away.
Welcome back to our current affair, very technical discussion. Now, we don't have much time left in this segment, the final segment, so I just want to ask Mr. West, Mr. Maharaj, and Mr. Archibald to quickly give us some summarizing points of how long they think this matter can go along and how technical it can become.
Well, I can see this matter becoming very technical. There could be a challenge after the magistrate commits, if she commits. There could be then go to the Court of Appeal and then Privy Council. And then there could be a challenge again if the Attorney General issues his warrant for surrender. So there could be anywhere between 3 to 5 years.
Mr. Maharaj, is there any possibility that he could get off easier, more easily, if he becomes a witness and cooperates with the U.S. authorities?
But I share Mr. West's view first that this can take a very long time, and Mr. West is very experienced in this field. I had the benefit of him when I was Attorney General, seeing about these matters, and I know of his expertise. In respect of a possible negotiation with the Americans, I really cannot comment on that because I do not know what are the facts, and I do not know what attitude the Americans would have. But I think we should really understand that there's a presumption of innocence too. And we should wait really and see what really is the outcome of these matters, because apart from judicial review, there is also the question of a possible constitutional relief pursuant to Section 14.
Okay.
And therefore there can be a long drawn-out matter here.
Okay, thank you very much. Mr. Archibald, very quickly, in 30 seconds, can you tell me, given your experience on the U.S. end of things, any possibility for leniency for Mr. Warner if he decides to cooperate?
Well, as Mr. Ramesh had said, you know, he is presumed innocent until proven guilty. That being said, our statutes and our sentencing guidelines are such that people who become cooperating witnesses do get a lot of leniency. And in these crimes, you're looking at 20 years per count that he's facing. And if he were to be a cooperating witness, he certainly will shave a lot of time off of that. But getting back to the extradition issues, is one thing we didn't discuss. If he is successful in challenging his extradition, he will be entitled to be reimbursed for all the attorney's fees that he spent in regards to that.
All right, that's all the time we have. I'm sorry that we had to cut it there. I see Mr. West shaking his head. We just want to tell you before we go that we invited the government to participate, the government side to participate in this, but they couldn't make it. Thank you to all of the gentlemen, experienced lawyers, for joining me this evening. Thank you for contributing to the program. This is A Current Affair. Join us next week, Saturday at 7:30 after the news. And don't forget, A Current Affair will be rebroadcast on Tuesday at 9:30 a.m. Good evening. Sorry, we can...